5 seconds. The reliance by the High Court on the earlier decision of the Punjab and Haryana High Court while allowing import of capital goods is clearly misplaced. That writ petition was concerned only with the question of import of machinery for the purpose of selling paddy, which would enable Oswald Agro to obtain the raw material required by it, namely rice husk. That petition was not concerned with the question of export of rice, and therefore the said decision had no application to the present case. The question whether the rice selling plant was a part of a 100% export oriented unit is wholly immaterial, while considering in the present case whether Oswald Agro could export non-basmati rice. It was also contended by Mr. Jethmalani that even if it be assumed that the High Court has taken an erroneous view and had wrongly concluded that Oswald Agro could export non-basmati rice, the court in exercise of its discretionary jurisdiction under Article 136 of the Constitution should not interfere. The facts as stated herein above, on the other hand, show that the High Court ought not to have exercised its jurisdiction under Article 226 of the Constitution for more than one reason, and therefore it would be incumbent upon this court to interfere under Article 136 of the Constitution and not to allow Oswald Agro to take advantage of an obviously wrong decision of the High Court. Firstly, the High Court misconstrued Clause 15J of the order and held that because Oswald Agro was an export-oriented unit, therefore it could export any item manufactured by it, which conclusion is wholly incorrect. Secondly, the High Court ought not to have entertained the writ petition because of Oswald Agro conduct. It had filed an earlier writ petition in the Punjab and Haryana High Court dealing with the same issue, namely its obligation and right to export its products under the license and in terms of the export control order. It is possible that the Delhi High Court may not be aware on the pendency of the writ petition in the Punjab and Haryana High Court regarding the export of edible rice bran oil, because there is no reference to the filing of the said case in the writ petition filed in the Delhi High Court. Oswald Agro is guilty of suppression of this very important fact. It was contended in the Punjab and Haryana High Court that it was under no obligation to export the edible rice bran oil, and its only obligation was to export furfural, while in the writ petition filed in the Delhi High Court, a somewhat contrary contention was raised, namely that being an export-oriented unit, it was entitled to export non-basmati rice in addition to pure fuel. Had Oswald Agro indicated in the writ petition filed in the New Delhi High Court that it has also filed a petition in the Punjab and Haryana High Court which was still pending relating to export of edible rice bran oil, then Delhi High Court most probably would not have entertained the petition because the proper course which should have been followed by Oswald Agro was to raise this contention regarding export on non-basmati rice in the writ petition filed in the Punjab and Haryana High Court or to file a new petition there.